My name is Jeff Morgan. I am from Dallas, Texas. I want to speak very briefly about a case taking place in the Commonwealth of Massachusetts, of all places, the Probate and Family Court Department. This is Marcia M. Dallmeyer versus Mark E. Dallmeyer, who is a defendant, docket number BE20D0220DR. This is the defendant's motion to dismiss. And Mark Dallmeyer is the defendant, or the respondent as we would call it here in Texas, in a matter of unilateral no-fault divorce. He's seeking to have this case dismissed because of the alleged grounds of irretrievable breakdown of the marriage. This case arises out of the plaintiff's desire for a unilateral no-fault divorce. Marcia and Mark had been married since June 25th, 1988. The complaint was filed October the 2nd, 2020. So they were married for over 32 years at the time that Marcia was filing for divorce. They did have a minor child. They do have a minor child. And this case is still pending right now. Mark is saying he's trying to get this whole case dismissed. He's trying to get it denied. He says that the action for the divorce should be dismissed due to insufficient evidence and defective pleadings that cannot be remedied. Why is he saying this stuff? Because according to the code that Massachusetts has in place, they don't have to make any pleadings. They just have to say that, the marriage is insupportable without any evidence whatsoever, no facts, that if you just state that the marriage is irretrievably broken, that they can be given a divorce. And what Mark is doing, he wants to keep his family together. He wants to save his marriage. He wants to maintain his legal rights as a married person. Divorce in itself, as tragic as it is, can be a remedial action at times. If you are in a relationship with someone and your wife is cheating and you're, nonstop and she's bringing home sexually transmitted diseases, there are reasons that you can get a divorce. If your husband's beating you and maybe he's out cheating as well, that's a remedial action. You can get a divorce for that because marriage is supposed to be an institution that you have certain rights and obligations. And one of the rights that you have from your partner is sexual fidelity. You have sex with each other, not with everybody outside of the marriage. And, there are other obligations that are entailed in that. If you're a Christian, you get married because you believe that marriage itself also carries with it religious connotations. You get married and a lot of churches say that you get married, there's the man, the wife, and then there's God at the top. This is the triangle. This is the successful marriage. And the closer you draw to God, the closer you draw to each other. This is what's being taught in a lot of churches, right? But the state is saying, well, wait. We don't want to have God at the top up here. The state wants to be in charge of this. We're going to kick God out of it. See, marriage was originally designed by God. The first marriage was performed by God. And marriage holds a very special place in the plan of God. You can make the case, at the very least, that marriage has a religious component. To some people, marriage is only a religious institution. To other people, it's just a civil institution. It has no religious connotation. To many people, it has some of both. But if it has some of both, you cannot dismiss the religious aspects of the marriage that the two people enter into. And if two people get married in the church, they take a vow to God, and they say, hey, till death do us part, that is something that needs to be considered. The state should not be able to abrogate a vow before God. A vow before God should have at least as much value and legal standing as a prenuptial, especially a vow taken before God in the presence of many witnesses. This is something that the state should not even be involved in. By the way, if you go back to 2015, Obergefell v. Hodges, Justice Kennedy said that marriage was a fundamental right. So the state should be upholding that fundamental right. And the state has to actually make the case as to why it can interfere with that fundamental right. See, divorce is not a fundamental right. It is a remedial right. It is a right that if your spouse is doing something that is violating the terms of the marriage, the state can say, wait a minute, this is outside of what should be done here. In this instances, perhaps we can grant the divorce. We would always seek reconciliation first, generally speaking, but if not, we can grant divorce under remedial instances. Unilateral no-fault divorce says, for any reason, for no reason, you can make up a reason. You don't have to even have a reason, but you just say the marriage is insupportable. The state will back you up 100% of the time, and will often take the other partner's possessions, access to the children, perhaps the home, car, all sorts of things, and give them to you. You have violated your contractual obligations. You violated your covenant. You violated the marital relationship, and yet you get to be rewarded for this. You are acting in a criminal manner in a lot of instances, and you want the state to reward you and protect you. Many instances there are protective orders filed. We know this because we've actually had assistant district attorneys talk about this, that getting a protective order to be filed is good. It will help you out in your divorce case. False fabricated evidence, well, actually no evidence, false fabricated charges, and yet they can be used against you in a unilateral no-fault divorce. Anyway, what's happening in this case right here is that Mark is trying to state that the statute under which this unilateral no-fault divorce is being considered is unconstitutional, and that therefore the courts do not have any jurisdiction in this. Divorce is a creature of the state. It's not something that you have a right to. You have the fundamental right to marriage. The fundamental right to divorce is not a fundamental right. It is a right that the state has granted. It is a right that the Bible has granted under some very limited instances. It is not this unilateral no-fault divorce for any reason, for no reason, at any time you want to. That is communist. That is what Vladimir Lenin did in Bolshevik Russia. Unfortunately, right now, we say that capitalism is better than communism, and yet in our capitalist free America, we have embraced communist divorce doctrine. When Vladimir Lenin came into power, he did two things. He weakened the church. He said that marriage is no longer under the church, it's a civil institution, and he also sought to destroy the family, knowing that by destroying the family, you destroy society, and that creates a better society that you could more likely impose communism on that society. So anyway, I have addressed this whole issue a lot further in an upcoming video. It's about an hour and a half, but I wanted to just give the basic points here, just so that for those who don't want to go through the whole hour and a half and hear me opining and also analyzing from my perspective what's going on. But in summary, what the defendant is doing, he's contending that the divorce statute is void ab initio because it does not prescribe any legal obligation upon the parties for which relief can be granted. You can file for no-fault divorce for any reason, for no reason. You don't even have to have a reason. You can make up a reason. It doesn't make a difference. All you have to do is just say it's insupportable, it's irretrievably broken, and whatever those terms mean, nobody knows what that means. Then there's no test for those terms. I've known people that have claimed insupportability and irretrievably broken, and then they get remarried later on. In fact, in our Texas Family Code, if you get divorced, you can remarry each other within 30 days. How about that? Irretrievably broken, but you get remarried within 30 days. And by the way, the only person that you can remarry within 30 days is the person that you just divorced under this irretrievably broken statute. Amazing, isn't it? Irretrievably broken, what does that mean? Nobody knows. The defendant contends that the divorce statute is void ab initio because it does not prescribe any legal obligation upon the parties for which relief can be granted. It does not create a legal liability. It does not provide the defendant an opportunity to avoid such an action. If you're the respondent or the defendant in a divorce lawsuit, it is a lawsuit, you cannot win. And that says something right there. There's a predetermined outcome against you. So what that's saying is that due process is not in place. Equal protection of the laws is not in place. You are being discriminated against because you are a defendant in a lawsuit. That is a special law, and at least in Texas, Article 3, Section 5613 says that the legislature is forbidden from making special laws granting divorces. Yet our Texas legislature has done just that. It does not grant the defendant the right to defend his legal interests. This is a violation of the 14th Amendment. And by the way, this is very important because there are very, very, very many legal interests that are enshrined in the issue of marriage. And Justice Kennedy, as I mentioned, I think, Obergefell v. Hodges, stated that marriage, I think, can bestowed over 1,000 rights upon the married couple. And how can we deny this of same-sex couples and homosexuals and lesbians who want to get married? It's a fundamental right. How can we dare deny this of these people? Because marriage is a fundamental right. And yet, in a fundamental right, the state has to prove the burden as to why they should violate that right. And in a situation of forced divorce, unilateral divorce, the state will take away the very rights that Justice Kennedy says should be given to same-sex couples. This is the essence of raw tyranny. This is evil and wicked. It regulates viewpoint rather than conduct, a violation of the First Amendment. And the purpose that he's saying this is because when you claim irretrievably broken and your spouse does not, the state always chooses to side with the person who says it's irretrievably broken. That is a viewpoint. I'm very glad this is happening in Massachusetts, because last year there was a case called Shurtleff versus the City of Boston. And it was a case in which the City of Boston discriminated against this group, did not fly their flag because the flag had a religious symbol on it. The City of Boston had flown 270 flags, I believe it was, but one flag they would not fly because it had a religious symbol on it. So this went all the way up to the Supreme Court. And the Supreme Court, they usually decide things 5-4 or 6-3 or something like that. 9-0. Every single judge stated that Boston, the City of Boston, had committed religious viewpoint discrimination against this person, Shurtleff. And what's happening with marriage is when you have a person alleging insupportability, the state is automatically siding with that person. That is viewpoint discrimination. If there's a person who's saying, look, I don't believe in divorce because of my religious convictions, whatever, we got married in a religious marriage, that is a religious viewpoint discrimination issue. Regardless, this is a complete violation of a person's right. You punish people because of actions that they do, not because of thoughts that they think. If we start punishing people because of thoughts that they think, we will all be in prison at one time or another. For example, if I think I want to jaywalk, if I've thought about it but don't do it, I've created no legal infraction. I've done nothing. If I actually jaywalk in a place that enforces jaywalking, even if I'm not even thinking about it, they can book me because of my conduct. When it comes down to unilateral no-fault divorce, it is only viewpoint based. You don't have to have any facts. In fact, facts are not necessary whatsoever. You can make up facts if you want to. You can make up anything as you want to. That's why perjury is rampant in family courts, anti-family courts, and the state defends it all the time. A divorce is the state-sponsored preference for legal outcome based on ideological viewpoint. It discriminates against a fixed defendant class and favors a fixed plaintiff class, which is a violation of the 14th Amendment. What does this mean? It means that anybody who files for no-fault divorce gets it. Even if the other person contests it, that person will always lose. The person who wants a divorce will always get it. This is discrimination against the person who is the respondent to a divorce. It is a vehicle for civil asset forfeiture, which is the violation of numerous constitutional principles. When you go through a divorce, usually what they do, they divide up your assets, they divide up the children, custody, they may make one person pay child support, they may say, well, you have a retirement thing here, we're going to do a quadro, we're going to split this up as well. Why should that person who did not want a divorce have to split up anything? This was created for the marital estate. If a person wants to leave the marital estate, they leave behind all the assets within the marital estate. If I quit my job, I don't take the stuff that I have with me from my work. I have to return it. In fact, when a company goes to fire you, often what they will do is they will turn off access to the computer system. They will take things away. They will escort you out the door as they're telling you, what a wonderful employee you've been or whatever. They're firing you, but they're going to make sure that you take nothing with you. You're not going to take customer lists with you. You're not going to take computers with you. You're not going to take hard drives with you. You're not going to take books with you. You're not going to take your notes with you. These are all property of the company. You may never have access again to your email. You may have had lots of personal emails. You may or may not have access to them once again once you leave the company. When you leave, you leave. You leave everything behind. If you decide you want to leave a marriage, you should be leaving everything behind. It dissolves the marriage contract without default or assent. And this is a violation of the Contract Clause, Article 1, Section 10 of the United States Federal Constitution. Talks about the Contract Clause, and he also mentions the case Dartmouth versus the Dartmouth College versus Woodward back in 1819. This was very much discussed at that point in time, the idea of the Contract Clause being violated. And furthermore, the entire unilateral no-fault divorce statute was written, designed this way. I believe it was designed by attorneys so that attorneys could profit, they could snooker the people, and plunder you for millions and billions of dollars. That's what I believe. They destroy families in the meantime, and they try to portray themselves as being they just care for the kids. While they're destroying a kid's family, they will act as if they want to. They're going to act in the best interest of the child. They're lying to you. If you are a Christian divorce attorney and you are going forth and creating divorce simply for money, You are not a Christian. You need to repent. You should have no leadership position within the church. You should be recognized as a non-believer, in my opinion. Anyway, he just says that granting this divorce will only be further vindication of what the defendant puts forth here as being credible and valid. And he also says, too, that the statute does not confer any subject matter jurisdiction upon the court because it is plainly void. A void statute confers no rights. It imposes no duties. It affords no protection. And it creates no office. Norton v. Shelby County, 118 U.S. 425, 442 in 1886. Governor Mike Huckabee, when I spoke to him a few years ago, he said, Jeff, no-fault divorce is the worst thing that has ever happened to America. President Ronald Reagan, who signed no-fault divorce into being in California after being lied to and deceived, but he did sign it into being, later on in his life said it was his biggest regret from public office. Unfortunately, in Texas, we have allowed this to go on. Again, I am very critical of our Republican, conservative, constitutional, Christian representatives and senators. I expect some of the Democrats to care less about this. But you people, you legislators, I don't care if you're man, woman, I don't care if you're black, white, who you are. If you claim to be a Christian, constitutional, conservative, Republican, we're fighting for faith, family, and freedom. We've had over 20 years that we could have gotten rid of this ungodly, immoral, unconstitutional act, and we have failed to do so. And I know that I've spoken with some of you legislators personally, a number of you legislators personally, as you know. I've been doing this for 8 years. I've talked about this issue. Oh, you get on board for a little bit, but oh, it's not that important. Oh, we're not going to do this right now. We have more important things like naming highways after people, or naming perhaps we're going to name a post office after somebody. That's much more important. We're going to talk about catalytic converter theft instead of the issue of marriage. Shame on you. Shame on all of you for allowing this injustice to go on. I believe that you will stand accountable before God for your inactivity. That's my belief. You know, I've been fighting for this. I've obviously not been very successful, except that I brought about some awareness. But Mark Dallmeyer, I just want to say that there are many people throughout the United States of America. We stand behind you. Thank you for doing this. We will be behind you. Mark, I plan to contact you in the very near future here. Anyway, thank you so much for doing this. Once again, we have to go to Massachusetts because our own people here in Texas, the great state of Texas, we lead by example. We fight for freedom. We're conservatives. We're Christian. We're constitutionalists. And we've allowed this ungodly practice to flourish for years and years and years. We have the blood of children on our hands right now.